Good evening and welcome to our jurisprudence class. So tonight we would like to discuss the natural law school. And before we do that, I would like to just draw your attention to something and a slight modification we are making. And I'll tell you the reason why the modification is important. Usually, I will have spent this first major substantive lecture, discussing issues as what is jurisprudence, problem of definition in law, and how it makes complicated the quest to provide definition for jurisprudence. And I will have asked you to read and we discuss the case of Pelusian explorers. However, I have decided to defer that first generalized discussion to later part of the semester. The reason being that when we have been through some of the leading schools of jurisprudence, some of the various schools of thought of jurisprudence, and as we encounter the unique arguments and challenges associated with each of them, when we step back and want to ask ourselves, can jurisprudence be defined? Can law be defined? Why not? Is it possible? And so on. We'll be better positioned to be able to address that. Yes. So on that note, we start discussion of the natural law school. The point to note is that we have already stated in this class that when it comes to the issue of what law is, or the nature of law, or the essence of law, the responses which are given originally fall into two categories, namely the is question and the ought question. So there is what we call the is and ought bifurcation or division. We have the is question, they are associated with what we call the legal positivism. And then the ought question, they are associated with the natural law school. And out of these schools are given offshoot to some other variants. But invariably, each of the other schools can be associated with one of these two major schools of jurisprudence, namely either the natural law school or the legal positivism. But tonight, we want to explore the natural law school. And to start with, the natural law school is concerned with how the legal system of a particular society. I think some of you don't know how to put off the mic, so I'm putting the mic off for everyone. If you want to talk, you raise up your hand and then I will release you. Thank you. The natural law school is concerned with how the legal system of a particular society is to be judged according to universalistic standards. In other words, the natural law school holds the view that there is a universal understanding or universal conception of law. So therefore, there are certain features, certain hallmarks, which law must reflect, regardless of the particular society that you are talking about. Now, this is based on the assumption that there can be deduced from nature certain objective moral principles which can be deduced by reason and which form a prescription for human behavior. In other words, it is the case of natural law that if we look at how nature is, if you look at how the world is ordered, if you look at how things are in their natural configuration and setting, it is possible to discern or observe certain principles. And those principles are knowable or are inferable from the nature of things. And that is why they say that they are objective moral principles. That is to say that they can be known by every rational being who observes, as it were. And for that matter, those principles should guide how human beings live their lives. So what natural law proposes that there are principles of law stronger than any man-made positive law. And for man-made law, known as a positive law, to be valid, it has to accord with these higher principles. In other words, to the mind of a natural law thinker, it is not enough for we to say that the lawmaker in a particular country or legal system has posited or has put forward a particular law as a law. More importantly, whatever is proposed as the law or whatever is postulated as law should actually satisfy the requirement of morality. And these principles of morality, as I have said, they think can be deduced from how nature is or how things are. So that is the first point that we have to keep in mind. So natural law school will say that the validity of the law should be tested. In other words, what the law is should be based on a higher law dictated by nature and should be what the law ought to be. So what the law ought to be is what is important and not what the law is. So that is another thing that we have to observe from natural law school. So what the law ought to be, that is certain principles of morality being met are more important than just what has been put forward as a law. So to an extent, nature here, which natural law scholars refer to, means that certain principles which are so agreeable with the state and nature of man that a failure to observe such principles will necessarily lead to breakdown of society. So like they are seen more or less as a fundamental principles, basic principles. So therefore, natural law is principally a theory of morality in general, and not strictly a theory of law, if you wanted to argue that way. And maybe not to, before we move on, from your constitutional law, you encountered the concept of constitutionalism. The concept of constitutionalism, and before I move on, can somebody in 1 second tell us what constitutionalism means? Somebody should put up his hand before I just call anybody. Quick. Whose hand is up? What is the meaning of constitutionalism? Yes, Richard Appiah. Richard, appear on mute. Good. Okay, Richard is not muting. Professor Owa Samson.
Okay, hello, my lord.
Yes.
Yeah, so constitutionalism can simply be explained as the breaks or the limitations that the law seeks to put on organs of government to prevent the arbitrariness of some states of organs of state, basically.
Absolutely, absolutely, Prof. I mean, you're spot on. Yes. So constitutionalism, the idea that there should be restraints. There should be restraint on exercise of governmental power. And from your constitutional law, you'll be told that having a constitutional government is not necessarily a guarantee of constitutionalism, right? So constitutionalism is more or less, ethos, a sense of value that there's a need to circumscribe, to limit exercise of governmental powers in order to avoid arbitrariness and safeguard liberty of the citizenry. So you see a point of convergence with what natural law is also saying generally regarding law, that man-made law, positive law, must reflect principles of morality, as it were. So let's keep that in mind. Maybe before we move on, it is also important to say that, in terms of general postulates of natural law, they will say that law must reflect higher principles of morality, and these higher principles of morality are universal. Universal in the sense that they are valid everywhere. And they also say that these principles of morality are absolute. Absolute meaning that they do not permit exceptions or they do not permit derogations. So let's keep that in mind. And if you go to the ancient Greeks philosophy, we can even go back to Socrates, but we've just started from Plato. Those of you who are familiar with a bit of classics, you remember the dialogue between Socrates and some of his students, especially Thrasymachus, just before Socrates was executed. Socrates had been tried for corrupting the youth of Athens, simply because Socrates had engaged them in a lot of critical reasoning, by asking them series of questions in order to demonstrate that a lot of things which are assumed as true or which are taken for granted without critical reflection are not as they seem to be, and so on and so forth. And this offended the people of his age, and they thought that Socrates was introducing strange ideas and probably strange gods, which were unknown to the Greek society. And that led to the conspiracy of his death. Charges preferred against him, he was tried and all that, and so on and so forth. And then just before he was awaiting for the ship to arrive for his execution, his students had various discussions with him, and things like what the justice is. Somebody will, when we say justice, what is it? And then Socrates will try and tear apart whatever responses that will give. And so from the various conversations Socrates had with his students and all that, we get some ideas which point to the existence of higher principles of morality. But Plato was also a student of Socrates. As a matter of fact, Socrates did not write a single book. It was Plato who, in his writings, made recollections of some of the teachings of Socrates. So Plato was idealist philosopher, and he did a work. He did so many works, including the philosophy of forms and so on. And of course, Plato will go to the sense of telling us that the things that we perceive with our natural senses, such as our eye, nose, and so on, those things we see, which we think can be subjected to empirical verification, you can touch and feel it. Those things which we think are rare, according to Plato, are mere shadows of the rare thing. In other words, in the mind of Plato, the things that we do not see are the rare things, and the things that we see are just the shadows of that which we do not see. And what does that mean? And those thinking, among other things, will lead him to propound the idea of justice as an absolute thing in itself, having qualities of truth and reality higher than those of positive law. So justice in Platonic reasoning, or according to Plato's thinking, is simply that that human beings or things should pursue that which they are designed to be. Of course, he also talked about the idea of social stratification and so on, that whichever station in life or whatever background that you are born into and so on, if you remain true to that, then that is justice, among other things, so to speak. So to Plato, we know what justice is innately. Law must constantly strive to approximate to the absolute idea of justice. And ideal justice for Plato could only be achieved or fully realized in an ideal state ruled over by the philosopher-king, who has the capacity or the ability to grasp the absolute idea of justice. So here we talk about the fact that we have people whose duty is just to, or whose circumstances and how they are made, is just to live their labor. We have others who are supposed to do, if you like, the middle class job. And we have those who are supposed to serve as soldiers. You have like few others, just one person or crowd who are supposed to be like the elite, the real rulers. And among them, there's what we call like the philosopher-king. And this philosopher-king, he has the ability to grasp the true idea of justice. So to know law, according to Plato, if a law is just, the philosopher-king must look for qualities of justice within the law. Only laws which pursue the ideal of justice can be considered right. So here you see that he's equating law to justice, that if law is not delivering justice, then it is not law. Now, another student of Plato is Aristotle. So if you look at it, Plato studied at the foot of Socrates, and Aristotle studied at the feet of Plato. Unlike Plato, Aristotle pointed out that the source of ideas like justice can be found that the source of ideas like justice can be found in human nature and is not external absolute idea. So if you look at the Plato is trying to say that yes, real justice is out there and it can only be grasped by a certain person with a certain superior quality, so to speak. But Aristotle is saying that no, that is not necessarily the case. Now, it was essential to Aristotle to understand human nature. And understanding human nature would only be understanding man's purpose. So human beings, do we have purpose? Aristotle will say that yes, we are not purposeless. We are supposed to be purposeful. So we'll talk about teleos, T-E-L-E-O-S, teleos. That is a Greek word for purpose or goal. And for that matter, you say that, yes, law and institutions of society are supposed to be teleological, Teleologica, teleological, that is supposed to be purposeful, supposed to achieve certain ends. Of course, don't forget that it's the same old idea, which has metamorphosed or crystallized into the modern approach of purposive interpretation, so to speak, in the statutory interpretation or constitutional interpretation, as it were. So, to Aristotle, man had a social and political purpose: to live in a political community and attain good life. So there is something we call polis, P-O-L-I-S, polis. So the polis in ancient Greek society was called like the city state. And that city state, in Aristotle, observation and conviction, the city state was supposed to be the ideal societal arrangement in which a human being should live. And that when you live in the city state, the polis, that's how they used to call it, you'll be able to realize your full potential as a human being. And that is why in one of his writings, he will say that a man is a political animal. When we say man is a political animal, it's in relation to the fact that people are supposed to live in the polis, the city states, in order to realize their full potential. So the thinking that man should live in a well-organized political community had consequences for law and should help him strive to achieve such purpose. One of such consequences is the emergence of the principles of natural justice, which is common to all mankind and is based on the fundamental purpose of human beings. That is to say that the state of goodness. So, yes, he will identify various types of justice and all that. But he makes the point that if for nothing at all, natural justice is very applicable to every human being. And the natural justice here has to do with that which conduces to state of goodness, as it were. Now, after Aristotle, we come to the Roman era. So in the Roman era, we have scholars like Cicero. Cicero was a great orator, very good speaker, and a lawyer. So Cicero advanced the explicit claim that natural law provides universal moral principles, obliging not only Roman citizens, but all human beings. In other words, Cicero would say that the natural law is universal. In fact, if you look at excerpts from his work, and I think if you go to the library, they have this book, MDA Freeman, Law's Jurisprudence. I think we also have like the PDF, so we share the PDF with you as well. Now, if you go to excerpts, that is the few sessions which have been extracted from Cicero's work. Cicero will make the statement that the law of nature, that is the natural law, what he calls it, is universal in the sense that it will not say one thing in Rome and another thing in Athens. That is to say that if you go to Rome or you go to Athens, Athens is the capital of the Greeks, it's the same everywhere. Maybe if you like we used to have this saying that everywhere you go was it MTN or something like that. I think there used to be some marketing jingle like that. So the natural law in Cicero's thinking was like that. And then Cicero will also make the point that natural law is propounded by nobody. You don't need any legislator to propound the natural law. Natural law is knowable by everyone by making use of your reason, your conscience, and all that. And then he also makes the point that natural law does not need anyone to enforce it. The natural law does not need the police, does not need the court, does not need, if you like, the military, as it were. The natural law can enforce itself, because to him, if you disobey the natural law, you can never escape its punishment. So, Cicero's writings on natural law were influenced by the philosophers called the Stoics from the ancient Greeks, and who proposed that nature can be identified with man's reason. That man live naturally when he live according to reason, and the precepts of reason have universal force. So if human beings, if you are living according to the dictates of reason, then in Stoic thinking, which influenced Cicero, we are living naturally. According to Cicero, therefore, the test of good law was whether it accorded with dictates of nature. Any positive law which contravened natural law ought to be struck down. And then, just like other scholars say, they say that an unjust law is not law. So that if the law lacks the quality of justice, then to Socrates is not law at all, as it were. Then, the natural law can take us even a whole year if we are to study only that. So we are using a very, if you like, an abridged approach, so to speak, so that we can cover all that we need to cover. But then you are referred to, textbook references to read more about it. Then we also come across St. Thomas Aquinas, a Dominican friar or a priest who was really brainy, and he, before St. Thomas Aquinas, natural law thinking was seen in two divergent perspectives. One viewpoint was that you could not talk about natural law without making reference to God. Another viewpoint was that you could talk of natural law without making reference to God, and you could just rely on reason. So these were the computing approaches to natural law thinking. Now, when Thomas Aquinas appeared on the scene, he argued for a synthesis, that is combination of law based on the premise that all things come from God, who is the highest form of good, the sonum bonum, if you want to use the Latin expression, sonum bonum, the highest form of what? Of good. And that God created nature, which has an order. And the existence of such order presupposes a reason. In other words, Aquinas is saying that natural law based upon God and natural law based upon reason are not mutually exclusive. The two are not contradictory or antithetical to each other. The two can coexist meaningfully and sensibly. And how did he do it? He argued that, yes, everything comes from God. And if you are talking about good things, then God is the highest form of good. God is super excellence, par excellence, everything good you can think of. God is the one. And then nature as it is, the physical environment, the world and everything as it is, was created by God. And God is the highest form of good. And if you look at nature, nature has its own order. Nature is not disordered. For example, you look at how the world and the seasons are. For example, there's no doubt that there's a certain order. Since we are in a Christian university, I refer you to Psalm 19, okay? Psalm 19, for example. If you look at Psalm 19, it will, look, let me just read the Psalm 19, verse 1 coming. The heavens are telling of the glory of God. And the firmament, that is the firmament refers to, like, you know, the world out there and all that, the skies, everything. And the firmament proclaims his handiwork. Day to day pours forth speech, and night to night declares knowledge. There is no speech, nor are there words. Their voice is not heard, yet their voice goes out through all the earth, and their words to the end of the world. Unquote. In other words, what the psalmist is telling us in Psalm 19 is that if we look at even the world, now is in the dark, isn't it? After some hours, we see the light. It will get to a time that we see the rainfall, you see the sunshine, and nobody is anywhere saying that let day come, let night come, let sunshine, let rain fall, and so on and so forth. But everything follows in a proper order. So according to accordance, this order has a reason. So there's a reason for the order. And law, in all its manifestation, flows from divine reason, as it were. So accordance will provide a typology or fourfold classification of law. Accordance will identify what we call lex aeterna, lex divina, lex naturalis, and lex humana. So let's take them one after the other and find out what he meant by them. The lex aeterna, according to Aquinas, is the eternal law which reflects God's plan for the universe. So just like the Psalm 19, verse 1 going that I read, like the seasons, the planetary system, the laws of nature and things like that. That is God's plan for the universe, for the created things. It is known only to God, and all things, both reasoning and unreasoning, are capable of knowing this. Please just 1 second. Oh, I'll be talking for some time. I didn't know I'm talking. Oh, just my intent was off. I didn't know my mic. Sorry, and I have to repeat myself. So I was making the point that by the less eternal, just the law God has given to all creature things, both reasoning and non-reasoning. And for example, every let's say if you take those in the animal species, they know when they are hungry, they know when they have to look for water. If you have a dog or goat there and there's water, it will go and drink water when it is thirsty. It will defecate when it needs to. It will cross when it is on heat. It is, and so on. So these are things which are part of the eternal law. And no wonder, somebody will say that I want to attend to nature's call. So attending to nature's call is an example of, if you like, the eternal law. And then we also say that you cannot cheat nature. There are times that the body needs to rest or needs to sleep. If you decide not to, the body can shut itself and all that. So they are all somehow manifestations of what we call the eternal law. Then we also have what we call the divine law. So the divine law here, let's define that. We are talking about God's revelation through the scriptures. If we take like the Bible, God has revealed a certain knowledge to human beings for our salvation, for our redemption. So that is God's positive law for mankind. For example, you take the Decalogue or the Ten Commandments, the examples of the lex divina. You take the Lord Jesus taught the summary of the command, the golden rule. Love of God, love of neighbor. Don't do to others that which do not want to be done to you, as it were. So all those things are examples of lex divina, divine law. Then we also have lex naturalis. Lex naturalis, that is the natural law proper. The natural law which results from the participation of rational creatures in the eternal law through operation of reason. So the eternal law is for both reasoning and non-reasoning creatures, right? Because that is God's law for the created world. But we also have rational creatures, human beings, who can observe the eternal law using their reasoning ability, and will be able to deduce certain precepts, certain fundamental principles. For example, when man reasons, he comes to know that fundamental principle of natural law, that seek good and avoid evil. Every human being, regardless of how perverse the person is, in his or her inner recesses, is aware that you need to do good and avoid evil. And this fundamental precept or principle, according to Aquinas, is self-evident. You don't need anybody to prove it. And that is why in our language, we say that obintre akwale nyame, okay? Obintre akwale nyame, it's a very cryptic way of talking about, if you like, the self-evidential nature of natural law. So everyone knows what is good, and everyone knows that evil should be avoided. And when man participates in natural law, when man participates in eternal law by using his reason, okay, man will come to know that self-preservation is the first precept or the first principle of natural law. When we say self-preservation, that is to say that every living creature would like to preserve itself or himself from harm or from destruction. And that is why when you are sick, you don't want to sit down without doing nothing. You want to keep yourself alive. You want to avoid death, isn't it? You want to preserve your quality of life. The fact that we have hospital, the fact that we have medication, the fact that we have various intervention is further evidence that self-preservation is the first law of nature. If you don't want to preserve yourself, why is it that when you are sick, you don't just fold your hands and allow the sickness to take it natural? Because if you die, isn't it? You want to preserve yourself from harm. In the same vein, when you are in the house or you are in the classroom or anywhere, and there is any danger, you think first about yourself, how to keep yourself safe before you even remember that you have a husband or you have a wife or you have children or you have other siblings. It's very quite natural to us. And that is another evidence of man's participation in eternal law, the type of natural law Aquinas is talking about, lex naturalis. So this necessarily means that man has an inclination, man has an inclination to pursue good according to nature of its reason. So anything which accords to the precept of self-preservation, the inclination to do good, belongs to the province of what? Of natural law. So example will include avoiding ignorance. Human beings naturally would like to avoid ignorance. So all of us, we have a certain level of curiosity. You want to know, you don't want to be ignorant. Then we want to live in a community peaceably with others. You want to avoid causing harm to others. So all these are examples of what? Natural law. Now the fourth category of law which Aquinas identify is what we call the lex humana, man-made law or positive law. And this man-made or positive law, according to St. Thomas Aquinas, derives its validity from natural law. Yes, Aquinas is convinced that despite having lex aeterna, the eternal law, despite having lex divina, the divine law, and despite having lex naturalis, the natural law, it is still necessary to have lex humana, positive law, because natural law does not provide all or most of the solutions for everyday life. And there's a need to compel human beings to act reasonably. it's not everything that natural law, for example, provide immediate solution, or not all human beings can go very deep in making use of their reason to arrive at all the principles which need to govern every aspect of human life. So there's the need for man-made law, but the man-made law should still reflect principles of natural law. So the man-made law is supposed to be extension of principles or precepts of what? Of natural law, as it were. And this man-made law may be variable in accordance with time and circumstances in which it is formulated, but its essence is to be just. In other words, the less eternal law, divine law, natural law is the same everywhere. But the man-made law or the positive law varies because we live in different environments, we live in different cultures, and so on. Different resources, endowment. Despite the fact that there will be variation in the man-made laws, such as the municipal law of Ghana is different from municipal law of Nigeria, or South Africa, or United Kingdom, or Canada. Nevertheless, they should all be just. They should all advance the principle of what? Of justice. To accountants, a law is just when it is directed towards the common good. So where the law is seeking to achieve the common good, then that law has attained the quality of justice. And a law is unjust if it is contrary to the common good or divine good. So if you have any law which is inimical to the common good or divine good, then that is unjust. So for example, in Ghana, people for many years having been extracting gold and all that illegally and sometimes legally, but not properly done. We wake up one day and it dawns on us that our natural bodies, I mean water bodies, rivers, streams, and various mini lakes and lagoons and all that are getting seriously polluted. And it is these same water bodies that provide water for our plants, and in some places even for drinking. So therefore, if they are contaminated, then we are actually putting ourselves on the trajectory of drinking poison. And if you drink poison, if the toxicity in your system builds up to a certain level, it will lead to compromising organs of your body, and the next thing will be for you to die. So that way, extraction of the natural resources, be it gold, be it oil, or anything, which is done in such a way that it will still end up harming human life, will be against the common good. And that is not in accordance with the natural law. It's good to pursue wealth, but you don't pursue wealth at the extent, at the expense of the common good. If you will become rich and the rest of society will get their health seriously deteriorated and their lifespan shortened, then you are not advancing the common good. Aquinas will make the point that unjust laws do not bind man's moral conscience. So if you have a law which does not advance justice, then according to Aquinas, that does not bind any human being. That is to say that if you don't obey it, you are not doing anything which is against the natural law, because the law itself is not just. The unjust laws are to be disobeyed only to the extent that disobedience thereof will not lead to scandal. In other words, if there's a law which is against natural law, that law is not binding in conscience, and ordinarily you can disobey it. However, if your disobedience of it is going to result in greater chaos, greater problem, then because your disobedience of the unjust law will create greater problem, Aquinas will say that obey it. So mind you, he's making a concession that yes, unjust law is an evil, okay? And again, if your disobedience of the unjust law would also result in another greater evil, then if you compare the two, the greater evil which your disobedience will create and the unjust law itself, the unjust law become a lesser evil, then Aquinas will say that then that's why the fact that it's unjust, in order to avoid scandal, you don't disobey it. So in all other cases, we need to preserve the legal order as a whole. Then we also have Hugo Grotius, another celebrated proponent of natural law. And Grotius was a Dutch jurist who laid foundation for an international law based on natural law. So he wrote a very important work, Ac Ballum Ac Pacis, the law of war and the law of peace. And of course, many respected scholars would like to credit Hugo Grotius as the father of international law. In fact, he was so brilliant that the literature tells us that he got his doctorate of law, and when he was either less than 18 years or 16 years or something like that. He was so brainy. And according to Grotius, it is possible to think of natural law even if you did not want to base it on God. If we did not want to base it on God, mind you, the reason why, despite Aquinas' integration of reason and God as the basis of natural law in the 13th century, in the 16th century and 17th century, that debate is revived again, and Hugo Grotius will come in because of the Renaissance, the classical Renaissance period, those period, and then also subsequent Enlightenment, when there was so much emphasis on scientific reasoning or the use of the mind rather than faith and theology. The writings of Grotius were influential in the political, social, contract philosophies of Hobbes, Locke, and Rousseau, which were in part culturally responsible for the American Revolution. So we have what they call the social contrarians, Thomas Hobbes, John Locke, J.J. Rousseau, and the social contract theories. They are also aspects of natural law thinking. And basically, what do the social contrarians say, or the social contract theories? What they maintain is that society, and for that matter, the legal system we have it, creates obligation for obedience by the governed or the subjects because of a certain social pact or certain agreement which was made between individuals and society at some point to surrender their absolute no freedom in return for certain protection by the state or society. And some will make reference to the fact that in the state of nature, that is, before we came to have society, when we're just individuals in the state of nature, everyone was just trying to survive, and it was more or less survival of the fittest. Everyone could harm the other and have his or her way. And life was quite miserable, nasty, brutish, and short, because might was right. And in the face of all that, at some point, people decided that we need to surrender some of our freedoms to, excuse me, I have to, just a minute. Yes, my dear students, unfortunately, I have to end the class abruptly. We continue again in the course of the week. So I'll arrange with your class prefects during the weekdays. We'll find one or two sessions and do a bit more jurisprudence and then a bit of company law. My apologies, but you have something to think about. Unless someone has a very major question, otherwise I'm going to end the session now and then continue again.